Everyone, and welcome to week 3 of Philosophy 307, Philosophy of Law. My name is Professor Jimmy, or you can call me Jimmy, and I'm with you for another week. This week we're going to talk about legal positivism. Sometimes it's referred to as positivism. And if you recall this week, and the last week, we are going over the nature of laws. So one of the key questions in this class, as I mentioned in week 1, is what is a law? When someone calls something a law, what does that mean? And if you recall from last week, we talked about natural law theory. According to natural law theory, something is a law insofar as it's tied to some independent moral standard, some standard of evaluation. So just not just anything counts as a law. Um, this debate about what counts as a law ties into things like what obligations do we have to follow the law? What are we as citizens supposed to do? And a discussion from week 1 when we talked about Socrates evading law and his friends helping him by bribing guards, etc., and how that factors into civic virtue. And these are questions involving what do I owe my society as a citizen? These tie into immigration and borders and all kinds of other fun stuff. But we're not going to get into all that. Um, because before talking about the stuff, we really need to understand what a law is. And last week, the natural law theorists put in a pretty robust view of what counts as a law. There needs to be a tie from the law to morality or justice. And without that tie, you don't have a law. Um, this week, though, we're going to talk about a bit different view. It's probably the more commonsensical view and the view that most people probably hold. If you were to ask someone on the street, in Costco or online, just some random person, what a law was, their view is probably something similar or closer to legal positivism than it is the natural law tradition. Uh, so basically, positivists hold that um, a law is just something passed by a legislature, instituted by a king, put forward by a judge. A law is a social rule that causes people or incentivizes people to conform. So basically, laws are a certain kind of rule that society puts on citizens. So laws are basically rules that apply to citizens by the government. So as you can tell, in the legal positivist tradition, and there's a lot of different legal positivists and kind of legal positivists, what's really important is what institutions and governments do. What's less important, or not important at all, is the moral standards and justice by which they do it. So if a law is unjust, or we would consider it wrong, think back to your high school days or your civic classes in college and various places uh, about slavery laws in the United States. Um, whether or not slavery laws are in fact laws is a question that would divide the natural law theorists from the positivists. Positivists would say that, of course, they're laws. What counts as a law for the positivists? Well, it's just a social world that applies to people within a given territory or region. So, insofar as laws are simply the sorts of things that are passed by legislatures, the Senate, for example, House representatives in our own country, the Parliament in the United Kingdom, there's lots of examples of legislatures. These are bodies of politicians who write up, debate, compromise on, and pass social rules for the citizens of a region to follow. Well, those are just what we call laws. Uh, so it should be very obvious right off the bat that the positive law tradition and the natural law tradition are very distinct in how they evaluate the connection between law and morality. So, for example, if you read the start of the Declaration of Independence in the United States, we hold these truths to be self-evident that all men are created equal with certain inalienable rights. That phrase, what the founders are getting at, whether you think they're consistent or not, whether you even think they're right, what they're getting at there is something much deeper than just a government that passes social rules that apply to people in a territory. Because why talk about inalienable rights? Why talk about a creator? Why talk about, in other words, a separate standard of evaluation? So natural law theorists are folks who think laws should be judged according to this independent standard. And insofar as the independent standard shows the law to be adequate, it's a just law, for example, then it counts as law. Positives think that that's just a bunch of crap, and the founders are completely wrong about this in their view of natural law. Laws are just anything passed by a government or um, state legislature, anything along any sort of governing body that applies to people within a territory or a region. So you might think, and one way to think about the positivist view is it's very descriptive. It describes what laws are. They're social rules. They're passed by governments. They're typically enforced with things like taxation, regulations, sometimes confinement, and even violence and death, depending on the government. A law passed in Russia right now will likely be enforced by not just speech or fines, depending on the severity of the law breaking, etc., but it could be very, very swift and severe in ways that in the United States and other liberal democracies we would find foreign and strange, in fact, unjust. Positivists would say, well, that it's no less a law in Moscow because it's unjust. Moscow and Putin and the Russian authorities, and so far as they're authorities and they govern a territory we call Russia, they're therefore the governing institutions in that particular region or territory. And so they're the ones that pass the social rules, and that's just what we call laws. And you can see how the Moscow, the case of Russia or Saudi Arabia or any government or nation that we would consider to be unjust or unfair, how that the debate over what counts as a law would really divide natural law theorists from positivists. So a natural law theorist would think that somebody in that a law, so-called law in Russia, isn't a law at all. This is a familiar notion in civil rights debates, where people will often say things along the lines of, um, "There's no such thing as an unjust law," or "You can't break an unjust law because an unjust law isn't a law to begin with." Those sorts of sentiments, as commonsensical as they are in the context of civil rights, where we see people using various mechanisms and means at their disposal to try and get better recognition and protection from the state and from political and social institutions. That practice of highlighting the unjustness of law and calling the question whether or not an unjust law even is a law is an outgrowth of natural law theory, but it's one that positivists would find very foreign. Now, this is not to say that one can't be a legal positivist and still think that certain laws are unjust. That's not fair or not true. Um, because you very much could be a legal positivist and think there's just laws that are unjust. The question is whether or not you think injustice invalidates something as a law to begin with or not. So here's an analogy. Suppose you and your friend are having a debate over whether or not a particular object in your driveway constitutes a car. You think, no, this is not a car in my driveway because it's a body of a car. It doesn't have an engine, let's suppose. It's missing a few doors. It was once a car. It resembles a car, but it lacks the functionality of a car, meaning it can't get people from point A to point B. It doesn't have an engine. It lacks doors. It's been crumpled from a car accident. It's been totaled. So it used to be a car, but because of its state, because it lacks certain functions, it ceased to be a car and now just resembles a car. Whereas your friend might think, no, that's not how cars work. It's not that cars are purely functional things. The thing sitting in the driveway is it's a car. It's just a dysfunctional car. It's a car that doesn't work. But it's nevertheless a car despite lacking an engine and doors. So the debate is really over whether or not lack of functionality, lack of goodness in that object disqualifies it from being a car or not, right? So on one side of the debate, the lacking the engine and the doors mean that it lacks the function of transportation, thereby lacking the status of a car at all. Like that object used to be a car. It's now a broken car, an ex-car, a former car. The other side of the debate thinks the descriptive component of the car, what you would describe it as, like that thing as a car, is at least somewhat, if not completely independent of um, whether or not the car works or functions. So likewise, we can take that analogy and we can apply it to the law. The natural law theorist is someone who thinks the piece of junk car or piece of junk thing that used to be a car is no longer a car because it lacks functionality. But apply that lesson to law. So unjust laws aren't laws at all because they lack justice. They lack that key connection to the law and to justice. So, so this is sort of John Austin's take. John Austin was a legal positivist. So, see if I can move this little menu here. Okay, so this is a really cool quote from John Austin. He says, "The existence of a law is one thing; its merit and demerit another. Whether it be or be not is one inquiry. Whether it be or be not comfortable or conformable to an assumed standard is a different inquiry." So what Austin's saying there, in so many words, is that whether something is a law or not is a separate issue from whether or not it's a good law or not. Sound familiar? So whether or not the piece of junk in your driveway constitutes a car is a separate issue from whether or not it's a good car or a bad car. So this person would say a car that's been totaled is no longer a car. That would be the natural law theorist. The positivists, like John Austin, would say, no, it's a car. It's just a bad car because it doesn't have an engine or doors. All right, it's a piece of crap. It doesn't work. So it's a bad car, but it's nonetheless a car for being bad. So the existence of a law is one thing, its merit or demerit another. Whether it be or be not is one inquiry. In other words, that's one issue. And whether it is good by a certain standard, meaning a standard of justice or morality, is a separate issue entirely. So, and we can see that. So Austin's quote here really makes that point nicely. So laws are laid down by legal and moral superiors to guide those under their reign. Think of kings, think of monarchs, priests, popes, bureaucrats, if they're doing like soft laws or regulations, sort of like Chevron deference with the White House and the administrative state, separate issue. We may get to that later. Or just legislatures, right? Rules as laws are commands to citizens and institutions, basically from the government. They're basically orders from the sovereign. The sovereign is whoever's in charge of the government. Legislator, the president, the prime minister, the king, the dictator, the supreme ruler, the pope. I mean, you fill in whatever it is, you know. But that's what laws are. They're commands essentially. Um, and they could take divine rules. They could take political rules. But the point is, they come from a political or superior source, legally superior source. And really, what John Austin means by that is not having anything to do with justice. So the language is a little sloppy, but it's essentially superior. He just means more powerful. So the reason the king gets to dictate the law, the reason President Trump, President Biden, President fill in the blank, Prime Minister Macron, and the legislature in France pick your leader and leaders or institutions that lead. Uh, they're in charge because they're more powerful. So it's a very descriptive. It's what philosophers would say. It's not a very normative laden theory of law, meaning it doesn't tell us anything about the goodness or badness of the law. It's not built into the account. Um, so it's important to keep that in mind. So the key is that the key component, the key insight of positivism is that what counts as a law is not tied to any moral or divine facts, divine commands, anything that makes it legitimate in terms of justice. Um, so it's important to understand that positivists aren't denying that justice is important for evaluating a law. They think bringing in moral facts would be important. Um, the merits of the law matter. So the positivist isn't saying the merits are unintelligible or unimportant, but it's not determinative in whether or not it's a law in the first place. So if you really want to understand the debate between the positivists and the normativists, the positivists and the natural law theorists, it's really important to understand the analogy between the broken down item or object in your driveway. The fact that it's broken down, does that mean it's no longer a car? Like it used to be a car, but because it lacks an engine, it doesn't? It's not a car anymore? Or is it a car? It's just a crappy car. So depending on how you think about that analogy that is going to tell you a lot about how you think about the debate between the positivists and the naturalists. So there's also some problems with positivism. We talked about some of the problems with naturalism before. One of them being it's kind of hard to tell when you say something's natural, there's these independent standards. Like how the hell do we determine what they are? So that's like the big problem for natural law theory. But positivism has problems of its own. For one thing, it's really hard to apply and interpret laws without introducing moral judgments, right? So when trying to decide, for example, like if you have more offenses of a law than you have resources to prosecute, um, this is what you might call prosecutorial discretion. So my wife is a prosecutor, and what she often finds is you have more cases than you have resources to prosecute. So you really have to pick and choose the cases or the supposed alleged violations of law that you need to enforce. And that's going to come with moral and ethical baggage, right? You're going to have to introduce moral judgments into the equation in order to. You really need moral judgments. Um, this is where the distinction on the one hand and morality and judgment on the other is a little forced. So yeah, you could say the positivist could just say, well, that's the application of law, right? It's cannot be interpreted and applied. That's the application side of law. That doesn't tell us whether or not it's a law in the first place. But it's weird to say it is an odd thing to say that what counts as a law is wholly independent for how you interpret and apply it. So positivists are gonna have to explain that part. Um, and morality is even influences how we understand laws. Um, so so like what is it to say when you allocate land, like a fair allocation of land, or everybody gets their fair share, or how to divide things up, or a lot of times even rules, like whether or not the rule applies, what counts as a violation of law, these are all moral, these have moral components to them. So it's not really clear um, how you could have law without moral components and judgment sneaking in. Um, so it's important to understand that it's important to understand the positivists can say something like laws are not what counts as a law is not connected to morality and justice and things like that. It's easy to say that, but it's hard in practice to make that work. So I think the positivist problem is that it's hard to use law, apply it, even understand it without morality and moral judgments and ethical judgments, despite the fact that the positivist wants to draw a line, demarcate morality and the law. And the natural law theorist has a hard time explaining how it is that we come to know what these independent standards are. Uh, that's so those are two very distinct ways of thinking about the question and answering the question, what is a law? So when we circle back to this in various topics, this is going in the coming weeks, which view you take, whether it's the uh, natural law approach or the positivist approach, is going to also have implications for how you think about the law, how law should be formed, how law should be written. But it's nevertheless an interesting debate. I think it's still an interesting debate and an ongoing one because people's intuitions go different ways. So something to think about definitely. Until next week.